This week, clients have saved over $200,000 in dismissed court summons, debt collector court summons lawsuits, debt collector lawsuits. Now, what I want to do is I want to review my top affirmative defenses that will usually get any third-party debt collector back on their heels and make them think that this is not going to be one of those easy cases. And then I'm going to talk about something that specifically happened, because every case is going to have its own nuance to it. When I say nuance, something new, something that's not the same as another case. Every case is individual. I want to talk about something that happened with one that saved an individual $6,000, and this individual we were in the negotiation process of settling this case, and because we pay attention, we actually speak with each other in our office, and I listen to my staff. When something doesn't seem right, I don't just say steamroll it through, let's get this done. No, I back up, and I think I've spoke about this in other videos, is that when information is brought to me, I back up and I pay attention. And what I mean by pay attention is I look at the details and I pay attention to the potential options and from those options. Also, when you say pay attention, you know pay attention means two things. You can pay people to get their attention. You pay attention because if you don't pay attention, you can end up paying later. Just want to throw that out there for people, because I get a lot of people who, I won't even say it. All right, let's talk about some of my top affirmative defenses that you could use to stop third-party debt collectors that are suing you for debt that they have purchased. So now you do have to say this a certain way. That's part of the technique, the craft, things that they teach lawyers in law school. Is that when you say stuff a certain way, it gets across a certain way. And that will allow people to understand what you're saying and also make it seem logical for you to ask those. But I'm not going to get into that part. But what I'm going to do is I'm going to just give you my top affirmative defenses. And obviously there's always some new things that could come about with your case specifically. So when you're dealing with a third-party debt collector, you want to have them give you a contract with your signature. We call it a wet signature, and it's not because your signature is wet, like you just sat there and signed it and it has to be like this dripping signature on this contract. No, you want to get a contract with your signature. Now, most of them are going to send especially in today's world, is that they're going to probably send a digital signature. It doesn't matter. You want to make sure that you get that digital signature with your original contract for whatever type of account, credit card, auto, whatever. You want to get that original contract with that signature. And you want to review that contract also. Next thing is you want to get your privacy data statement that bridges that original creditor to give your information over to that debt collector. It is not just a bridge by them buying the debt. And what I say by bridge, that means that if someone is saying, I'd say bridge as so you can get a visualization. It's like the debt collector's on one side of the bridge, you and the original creditor are on the other side of the bridge. You have a falling out with the original creditor. How does that original creditor get to give that debt collector who's on the other side of the bridge, someone you don't even know about, someone you don't even know, someone that you're not doing any business with, how do they bridge that permission over to allow them to be able to have access to your information? Because that's basically what they're doing. It's like if you can imagine it, it's a bridge. They're going one way and coming back the other way after you. It's like they're building a bridge to allow that debt collector to come back after you. So you want to get that information. Next thing is you want to have them reveal the entire account number. Reason why you want to have them reveal the entire account number, because you could have multiple accounts. I've had clients who had multiple accounts, multiple credit cards with the same lending institution. You want to make sure that you get the appropriate full account number. You have a right to do that. You also want to have a document when they purchase portfolios. You'll notice this, is you want to make sure that they have in there that portfolio is 100% accurate. What you will normally see on those documents is that they will say that there's no guarantee that it is 100% accurate. So if the original creditor is stating that there is no guarantee that the information in that portfolio is 100% accurate, and they don't say, well, this account is not accurate or that account is not accurate, how do you know what's accurate? This is how you use their own documentation to tear apart their own case. Next thing is they cannot walk up to you and say that you owe this amount of money. Let's use that bridge again. Let's use that bridge theory. This debt collector comes over the bridge and says, we purchased a debt and you owe us $11,000. And you say, okay, what do you have to prove that I owe you $11,000? Now, I just stated some of the other things that you would question them on, but then they say, well, hey, we bought the debt and you owe us $11,000. Okay, how did that $11,000 get accumulated? So you want to have them show you proof of every dollar amount that would equal that 11, every charge to equal that. If you just had one loan, then you want to make sure it's going to be more on the other documents. But if you had a credit card debt that they purchased or any type of open-end account that they purchased, this is like one of your key mechanisms that you'll be able to utilize to stop debt collectors in a debt collection lawsuit. Next thing is you want to always ask if anyone in the process have filed a 1099-C, including the debt collector. Because I have seen this happen with my own eyes. Debt collector filed 1099-C and then they're suing someone. Original creditor, 1099-C filed, and they sold it to a debt collector and they're suing someone. And then all of a sudden they get a 1099-C in the mail later stating that that debt was forgiven through the 1099-C process. Entire amount, not a portion. They can't do that. So you want to put them on record that no one has done that. You want to have them do their homework to make sure that they haven't done it and make sure no one else has done it. Next thing is a dunning letter to the defendant, individual that owes the debt. It is required that they give you notice that they're attempting to collect the debt. Now, they might call, they might do all these different things, but they have to actually send you what's called a dunning letter. This is something that actually is supposed to be done before they even try to take any legal action, because that gives you the opportunity to dispute any or part of the debt, which is your right according to the Fair Debt Collection Practices Act. As a matter of fact, even an original creditor has to follow that process. If they're going to take legal action, they have to give you the opportunity. The next thing that you want to do is you want to look at all of the exhibits that they're putting in the case against you, and you want to verify, you want to, number one, verify if they're even accurate. I've seen it where some of the exhibits were part of someone else's account. I don't know how that happened, but remember, they're humans too, and people could get lazy, people could make mistakes. But you need to make sure, and also because they're used to getting default judgments, if they got 1,000, just imagine in the office of a debt collector, you're the paralegal who's getting this information together. You're part of the staff, and you got 1,000 cases to put together. You're going to copy and paste a lot of stuff, and a lot of mistakes can happen. A lot of mistakes can happen. But they're used to getting away with it because no one challenges the documents. The way your key to victory is to look at all of the documents and to start to tear apart their case with those documents. Now, that's some of the affirmative defenses that we use. And another one is latches, which is, especially when it comes to third-party debt collectors, is that if they put you at a disadvantage by waiting so long to do this case, what could be a disadvantage? Well, I don't have access to the records that they're claiming that I owe this amount. So they say you owe $11,000. I don't have access to any of the records because the original creditor states no communication can be done with them because they sold the debt to the third-party debt collector. They sold the debt to the third-party debt collector. That means that the third-party debt collector has an obligation to get all the records, because if I question how you got to that $11,000, you can't just throw one statement on the table, two statements on the table, and say, hey, I got 21. No, it's not going to work that way. But it works that way for them, third-party debt collectors, because no one's ever challenged them fully on it. So if they're not used to getting challenged on those documents that they have presented, because most of the cases end up in default judgments, or most of the cases people don't put up any affirmative defense, they're able to just walk through and just like rubber stamp all of these cases. So they are required, so they're putting their court summons up against, with their allegations stating owe this money, unjust enrichment, all of this stuff. But they don't even have all of the documents to even prove what they're even alleging. Most of them don't. Now, if it's an original creditor, that could be a different story. So now, let me get into what happened with a client this week. This client, we were working on a debt settlement. So we were in negotiations helping this client settle on a debt for $6,000. And remember what I said earlier is that when my staff comes to me or someone comes to us, we never just try to be like we know it all. We're not that type of company. What we do is we evaluate situations, evaluate what's going on, and then we look at the potential options that are available. And by doing that, what we've learned is that sometimes when there's something wrong with a case, it can reveal itself in a strange way. And what ended up happening with my staff member with this particular client is she came to me and she said, just something doesn't seem right. She says, something doesn't seem right. This company is saying that they want to negotiate, and when we get ready to, all of a sudden it falls through. She gets sent to another rep, like things are wrong. And so this is what I told her to do. I said, document everything. Just document the calls, document what we said, document what we've been experiencing, and then give that letter to the client, because this was a court case that was coming up. So she wanted to settle this case, but and it was $6,000 the case, but she wanted to settle it, and we were going back and forth. All of these problems were happening, and with dealing with the reps with the debt collection company. And we said, okay, I said, document it, give her a letter, let her go to court with that letter. She gives that letter to the judge. Judge reads over that letter. Guess what ended up happening? The debt collection company did not even show up for the case. And so they gave the debt collection company 1 full hour to show up. Now, I could just tell you that they don't never give individuals who have a default judgment against them 1 full hour to show up. But what ended up happening is, based off of the letter that we gave our client, judge had it in hand, waited 1 hour, didn't show up. Judge based a uh, dismissal, said dismissing the case based off of the information that was in the letter. So this client that did not respond to the court summons, because the whole thing was just to settle this before it went to court, because of what the debt collection company did. And now this is, let me tell you why, potentially why, I don't know 100%, but potentially why debt collector did not show up is because when I told my rep to start documenting everything, we also started sending them notifications of what we were doing, and that we were not getting responses, that we left voicemails, we left when we did get to speak to a rep, we notified that rep. Remember, they're recording all the calls, and we sent emails directly to the debt collector notifying them of what we were going through with them not negotiating in good faith. And the judge ended up dismissing the case. $6,000 that would have came out of our client's pocket. From my memory, I think that they were looking at doing payments on that they did not have the money to do a lump sum settlement on that case. So you never know what could happen. It is always good to really review what's going on with your case, and then review, if you're in negotiations with a debt collector, listen to what they're saying. If any part of it doesn't seem right, they usually know the issues that they have. Like on their screens, let me give you an example. On their screens, let's just say that the debt is past the legal statute of limitations, and they know that they're not even supposed to take that debt to court, but it could have accidentally been put into it, because remember, people make mistakes. It could have accidentally been lumped in with cases with the group that was going to be sent to have a lawsuit against. That could potentially happen. But on their screen, on the reps screen for debt collection company reps, it'll tell them if a debt is past legal statute of limitation, because if it's past the legal statute of limitation to collect, they are supposed to notify the individual on the phone that they're calling that it is a time-barred debt. And they don't use the word statute of limitations, but they have to notify that it's a time-barred debt. And they have their roundabout ways saying that you don't have a legal obligation to pay it. They just use different terms. Now, for this specific case I'm talking about with the $6,000, no, that was not a debt that was past legal statute of limitations. What we are thinking is that this debt could not be proven 100%. We always send out notifications, regardless even if the client wants to settle the debt, there is still a process that should be utilized, which is a debt verification / validation process to make sure that everything is given. Now, if you don't know how to do a verification or validation process the right way, what they're going to normally just send is some statements and stuff back to you. But there is a way to make one of the attorneys, whoever is going to be handling it, go on the record to state that everything is 100% accurate, that they've checked and they know how this amount came about, and they're ready to move forward. If you do it right, you sometimes will get where they're going to say, we're going to cease collection on this. And that's what I'm thinking happened with this. They just wanted to probably see what would happen. Sometimes if they if they don't go to court and the individual doesn't go to court, the judge will just move it to another date, because they're kind of a little buddy with these debt collectors. On, not that they're lean towards them, it's just that they see them all the time, so they'll give them that leeway, and they'll just say, we're going to reschedule the hearing for another date. So they'll do that. But when the defendant shows up in and the debt collector doesn't show up, and you can show that you had some sort of initiative, which she did with that letter. Hey, we've been trying to work stuff out. We've done this. We've done that. Have a company that's even working with me to even try to get this stuff done. When you have stuff like that, then the judge will usually just say, hey, we're going to dismiss this. We have defendant trying to do things. Debt collection company isn't negotiating in good faith, or they're not even showing up. But if you have your reasons showing that you've been proactive, it's going to, give the judge some good reasons on why they should dismiss the case. All right. So if you have a debt collection lawsuit case, there's a link below this video where you can get some help. We'll review it, give you some information on how you can fight back against third-party debt collectors. If you have original creditors, we can, give you some information on how you can kind of, in a way, you fight back on those cases, but you're basically getting yourself into a position to have a good settlement opportunity with original creditors. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch video What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, and Experian credit reports and all 3 scores. Very important. That's where everything starts. If you have debt collectors coming after you, grab my 3-pack of letters: statute of limitations letter, debt validation letter, cease and desist collection activities letter. Those can stop debt collectors in their tracks, save you time, money, and frustration. I do ask for a donation with those, but that's up to you. But you can, if you got debt collection letters coming after you, these have stopped debt collectors from coming after people. Thank you for your time. Please subscribe to the channel. Post your questions and comments. Like this video. When you like this video, I help you by making these videos. You like this video. By you liking this video, you help other people that need help. There's a lot of people out there that need help. Thank you for your time. This is Stephen A. Williams, president and founder of thecreditrepairshop.com.